I'm Talita Loubser. I'm a partner in the Employment Law Department at Bowman Gilfillan, and I'm talking to you today about POPIA, the Protection of Personal Information Act. This act is expected to come into force during the course of 2010, and a bill has been published for comment. This bill has been a long time coming, and the provisions contained in the bill, which will eventually become an act, are generally regarded as a codification of our common law on privacy, insofar as it relates to information of data subjects, as well as giving effect to the right to privacy as contained in our Constitution. The Act is designed around certain protection principles, which I will come to in a while. But first, the definition of what is regarded as personal information is actually quite wide. It includes all things that are inherent characteristics of a person, such as your age, your sex, your race, your religion, all those kinds of things. Also identifying symbols, such as a telephone number, an identity number, and your blood type, as well as opinions of other people about you. Importantly, it is related to information that's contained in a record. So if someone has an opinion about you that they just have in their heads, that would not fall within the scope of POPIA. As I said, the Act is designed around a number of protection principles. The first is that personal information must be processed in accordance with certain principles. There's a general misconception that personal information may only be processed with the written consent of the data subject, but that is not what the Act says. It provides for quite a number of bases upon which a responsible party, such as an employer or a financial institution, will be entitled to process personal information. Some of the other protection principles include the principle that information should preferably be collected from the data subject herself or himself. But again, there are exceptions to that rule, which are set out in the Act. What the Act really aims to do is to protect, on the one hand, the privacy of personal information, and on the other hand, to facilitate the transfer of information. So this Act will bring us in line with our major trading partners, such as Europe, the UK, and to a certain extent the United States. And it will actually facilitate the transfer of information across borders. A certain category of information is regarded as special personal information, and there are additional protection principles worked into the Act to protect this type of information. These special categories of information relate to things like your medical and mental health, a person's religion and philosophy of life, and trade union membership. So in those circumstances, there may be additional requirements that an employer, for example, will have to comply with in order to process the information. The Act is expected to come into force during the course of 2010, and should you require further information in this regard, for example, if you need to look at your HR processes in order to ensure that they are compliant, you are welcome to contact us and we will be happy to assist you.